What if you woke up this morning and your rights were already gone? Not because you broke a law, not because you were charged with anything, but because a new order quietly went into effect while you were still asleep. A single policy change, signed behind closed doors, now gives authorities the power to take your firearms today, without warning, without paperwork, and without so much as a judge reviewing the situation. No hearing, no warrant, no chance to defend yourself. One knock at the door, and everything you thought you were protected by can disappear in seconds. This isn't a prediction. This isn't a rumor. This is happening right now. A new gun confiscation order has officially started today, and millions of lawful gun owners have no idea what it means for them, for their families, or for their rights. This order expands law enforcement authority instantly, allowing firearms to be seized during routine calls, neighbor complaints, misunderstandings, or even vague claims of concern. The rules changed overnight, and you were never given the chance to prepare. A false report, a heated argument, or a worried bystander could now trigger a full confiscation with no due process whatsoever. And the most dangerous part? You don't have to commit a crime. You don't even have to be accused of one. Your guns can be taken simply because someone thinks something might be wrong. This is the new reality, the new standard. And starting today, every gun owner in America needs to understand what just changed. Because this order sets a precedent that could spread faster than anyone realizes subscribed to Survival Law Advisor. Because staying informed may be the only protection you have left. The moment this new order went into effect, the entire landscape of gun ownership changed without hesitation or delay. There was no rollout, no phased implementation, no time given for anyone to understand what was happening. One signature triggered immediate authority that empowered officers to confiscate firearms the second they arrive on a scene. Not tomorrow, not next week, today. Gun owners went to sleep believing one system existed and woke up under a completely different one. This new order was designed to activate instantly, bypassing the usual introduction period that most major policies require. There was no press conference warning people to prepare. There was no public debate. It was silently approved, quietly activated, and immediately enforced. The state didn't just update procedures, it fundamentally rewired them. Overnight. Because under this new order, firearm seizure is no longer optional. It is mandatory. Officers used to weigh circumstances, consider context, evaluate the environment, and determine whether a confiscation was necessary. But that authority has been stripped from them. Now, the rules tell them exactly what to do. Take the firearms, every time, in every qualifying situation, without hesitation. The law doesn't require violence. It doesn't require threats. It doesn't require a weapon being drawn or brandished. It doesn't even require crime. All it requires is for officers to respond to any situation categorized under domestic concern, disturbance, or potential risk. That single classification obligates them to confiscate all firearms present. Your carry permit is taken along with them. Your rights are paused. And the decision wasn't made by a judge or court. It was made by the person who dialed 911. This order replaces evidence with assumption and replaces discretion with forced action. This new order bypasses due process entirely. Under traditional red flag laws, at the very least, a formal affidavit must be submitted, then reviewed by a judge, and a signed order must be issued before any property can be taken. That level of oversight is gone here. Officers don't need a warrant. They don't need judicial authorization. They don't need probable cause in the constitutional sense. They only need a belief that something could be wrong. That belief, based on observation, tone of voice, environment, or third-party comments, is enough to initiate immediate confiscation. This isn't due process delayed. This is due process deleted. The judicial branch no longer has the first word. Law enforcement does. And with that shift, the legal barrier between your home and government intrusion becomes thinner than ever. Under this new structure, an accusation is not just an accusation. It becomes an automatic trigger. A neighbor hears raised voices. A passerby sees someone upset on a porch. A stranger misinterprets a conversation. A family member exaggerates a claim out of anger. That's all it takes. An officer doesn't need to witness a crime or verify the story. The report itself acts as a substitute for evidence. One statement from one caller can set the entire process into motion. You don't need to be arrested. You don't need to be charged. You don't even need to be questioned before the decision is made. Because under this new order, every situation is treated as if it could escalate, and that possibility is enough to justify confiscation. The state has shifted from the burden of proof to the expectation of precaution. A single misunderstanding can now redefine your legal status faster than you can explain yourself. And once your firearms are taken, the responsibility doesn't fall on the state to justify the action. It falls on you to prove your innocence. You must demonstrate that you are still legally allowed to possess firearms, even if you never broke a single law. Previously, there were clearer deadlines and shorter review windows, but under this new order, the timeline has expanded significantly. The review period that once required quick evaluation has grown into a multi-day process. What used to be 48 hours can now easily extend to 120 hours or more. That means you could go 5 days without your firearms, without your carry permit, and without clarity. And throughout that time, you are treated as if your rights are suspended by default. This process presumes guilt first and demands innocence later. Even more concerning is how this new order redefines the word danger. Traditionally, danger required visible threat, physical violence, or credible evidence. But this new policy broadens the definition so wide that almost anything qualifies. Officers no longer need to see someone being harmed or threatened. They don't need to observe violent behavior. They simply need to interpret that someone might become dangerous at some point. This interpretation can be influenced by tone, emotion, confusion, silence, or even stress. Someone having a panic attack, someone emotional from an argument, someone frustrated from a misunderstanding. These are now conditions that can be labeled as potential danger. And because the order prioritizes prevention, officers are instructed to take action based on prevention, not proof. This creates a moving standard that varies from one officer to another, one moment to the next. When the definition of danger becomes a feeling instead of a fact, anyone can fall under its scope. What makes this even more troubling is how openly this new order conflicts with long-standing Supreme Court rulings. Cases like Cornelia versus Strom explicitly ruled against warrantless home searches and gun seizures without due process. The court unanimously stated that the community caretaking exception cannot apply to private homes. The new order sidesteps that ruling completely by reframing firearm seizure as procedural response rather than judicial action. It claims compliance through language while violating the essence of constitutional protection. This is not just a questionable legal maneuver. It is a direct step around the very safeguards the Supreme Court has already affirmed. And whenever a state attempts to circumvent federal precedent, legal battles follow. In fact, challenges are already forming. Constitutional attorneys, civil liberties groups, and Second Amendment organizations are preparing lawsuits that question the legality of this order. The contradictions between the order and federal decisions are too significant to ignore. State courts will be forced to examine whether this newly expanded authority violates Fourth Amendment protections. Federal courts may be involved next. Emergency injunctions are likely. Appellate reviews are possible. And if enough conflict emerges, this issue may once again reach the Supreme Court. These cases are not just about this single policy. They determine how far the government can go in redefining rights under the label of public safety. Behind all of this, many believe there is a deeper motive at play. Rather than attempting a direct gun ban, which would face immediate constitutional resistance, this new order introduces a far more subtle strategy: restricting gun ownership without ever openly challenging the Second Amendment. By making confiscation easy, fast, and unreviewed, the state normalizes the idea that the government has the authority to seize firearms whenever it believes it should. This psychological shift is powerful. It doesn't prohibit ownership, it undermines it. It builds a pathway where future policies can become even more aggressive without triggering public backlash. This is the slow erosion approach. Rights aren't removed instantly. They are chipped away until the foundation is weak enough to collapse on its own. And make no mistake, this order will not stay contained. Other states are already paying attention. Historically, once one major state introduces a new gun enforcement model, others replicate it quickly. Officials in California, New Jersey, Illinois, and several others are watching the rollout closely. If this order withstands early legal challenges, it could inspire a wave of similar policies across the country. What begins as one state's administrative change could become a national trend. Federal agencies may even attempt to adopt portions of this model into future guidelines. This is how rights disappear, not with one bold announcement, but through repeated changes, one state at a time, until resistance seems like a losing battle. The state expects silence. They are betting that most gun owners won't fully understand what the order does. They assume people will not question the legal implications. They believe most families will only learn what changed when it's too late, when the knock comes at the door. But that silence is exactly what allows these orders to spread unchecked. History has shown that when Americans speak up, challenge unlawful policies, and defend their rights, they win. But when they stay quiet, the erosion accelerates. Awareness is the first defense. Understanding is the second. Action is the third. If you own a firearm, if you care about the Constitution, if you value the rights that define this country, you cannot ignore what started today. This is not just a policy, it is a turning point, and what happens next will shape the future of gun ownership in America. Stay alert, stay informed, stay prepared, and subscribe to Survival Law Advisor, because knowledge is no longer optional. It is necessary.